I'm Pete Weatherby from Garden Court North, and I'm very pleased to be the chair of this event, Descent into Authoritarianism, the Rajiv Menon KC case. It's sponsored by Garden Court North, Garden Court Chambers London, One Pump Court, and Nexus Chambers, and sponsored by the firms Bat Murphy's, Bindmans, Dayton Pierce Glynn, Bernberg Pierce, ITN Solicitors, Robert Lazars, Hodge Jones and Allen, and Kelly's. I'm pleased to see the enormous concern about this case, evidenced by the fact that we have had about 1,200 people register for this event, which is far more than any event that I've ever had the pleasure to chair. For the first time ever in this jurisdiction, a lawyer is facing criminal trial for what he said in his closing speech to a jury. Wholly unprecedented here, but in my experience, not uncommon in certain other jurisdictions, authoritarian ones, as I'll mention in a moment. It represents a very dark turn for the rule of law here. In a few minutes, I'm going to introduce a stellar panel of speakers, including icons of the bar and representatives of wider civil society. This is a public event, and the comments made by individuals are their own, rather than the chambers and firms who sponsored the event or anyone else, including Rajiv Menon. Please feel free to use social media, and we intend to record and publish the event after it's gone out live. So what's it all about? Rajiv Menon is a senior barrister at Garden Court Chambers who's appeared in numerous high-profile cases and is highly respected across the bar and, as far as I'm aware, by the judiciary generally. In the recent Filton trial, prosecuting counsel complained to the judge that Rajiv was in contempt of court, primarily because he told the jury about jury equity in his closing speech and had gone against the judge's rulings. The judge had not interrupted Rajiv's speech, as sometimes occurs, and of course, as is the case in all trials, the judge had the final say in summing up. Whatever Rajiv did or did not do, the trial continued. The jury was not discharged, and they delivered not guilty verdicts on some charges and were unable to reach verdicts on others. Subsequently, the remaining charges went to retrial. Objectively, whatever happened, the trial process was not unduly affected. It's not uncommon for a judge to take issue with something said in a jury speech. Invariably, it's resolved before the jury at the time. In theory, if it was not rectifiable in the process itself, the judge could discharge the jury, wasted costs could be ordered, a reference to the regulator, the BSB, could be made. None of that here. Resort to criminal prosecution is wholly extraordinary and unprecedented. You can read Rajiv's speech online. It is as forthright as one would expect from counsel doing their job properly. It's not for me to analyse the issues here, but Rajiv denies asking the jury to apply the principle of jury equity, and he asserts that he told the jury that they should follow the judge's legal directions. What he did do is remind the jury of their independence and that those legal directions included that they were the sole arbiters of the facts. I cannot recall a single jury trial in my 35 years at the bar where I have not reminded the jury of the same, albeit in ways tailored to the particular case. If you do read Rajiv's speech, you may also be struck by the fact that he plainly did not intend to stray over any forbidden boundaries. In my view, that is important to any decision as to whether to pursue a lawyer for their actions in defending their client, irrespective of the strict legal position. How could it possibly be in their public interest to pursue a prosecution against a lawyer if they had no intention to step outside of the law? Subsequently, the judge referred Rajiv to the High Court to decide what action to take in such a way that the Court of Appeal ruled unlawful. Undeterred, the judge has now referred the matter a second time to a presiding judge who has instituted contempt proceedings and listed it for trial before Ms. Justice Chima Grubb next Tuesday and Wednesday. I've already noted the matters that the judge chose not to do, including discharging the jury and reference to the Bar Standards Board. But he also chose not to refer the matter to the Attorney General an independent law officer. Why not? Rajiv's lawyers have submitted a further procedural appeal. As we've opened this event tonight, the breaking news is that the Court of Appeal have indicated that they are not able to hear the appeal before the trial date of Tuesday and Wednesday next week. But nevertheless, the trial judge has indicated that she intends to go ahead even though there is a pending appeal and an appeal as of right. Again, there are many firsts in this case, but that one is a first on me as well. Whatever the outcome, the question remains, if the judge considered that these facts merited the first ever criminal trial for contempt relating to a barrister's closing speech, why did he not refer it to the Attorney General? Both the judge involved and the judge who is to try Rajiv appeared in cases with him when they were at the bar, and he has appeared in cases before them both as judges. There is no evidence of animus towards Rajiv of which I am aware, but the appearance of this is obvious and awful. The independence of the judiciary and the independence of the bar are both vital to the rule of law. If there was a case to answer, so serious that the public interest pointed towards prosecution, it should obviously have been referred to the Attorney General, and I cannot begin to imagine why the judge thought otherwise. Before I hand over to others, I referred earlier to the criminalisation of defence lawyers in other jurisdictions. Despite international conventions to protect lawyers, prosecuting them is a tactic of choice in authoritarian countries with a poor adherence to the rule of law. I'll give you just one example. In 2019, I attended part of the trial of Selahattin Demirtas, leader of the HDP, the third largest party in Turkey, and he was a prospective presidential candidate. I attended on behalf of the Bar Human Rights Committee. The trial occurred in the aftermath of the 2016 alleged coup attempt, in response to which the state had arbitrarily dismissed a quarter of its own judges. The European Court of Human Rights was to find that the detention of Mr. Demirtas was a rare breach of Article 18, amongst others, meaning that it was politically motivated. But on the same trip, it came to my attention that one of the defence lawyers, who had also appeared in a number of trials criminalising journalists who criticised the president, was himself on trial the very next day for the crime of giving a newspaper interview where he questioned the independence of the judiciary. Is this where we are heading? The report of that case is on the Bar Human Rights Committee website, together with many others, chronicling the criminalisation of lawyers in other countries. The criminalisation of defence lawyers is not only an attack on them personally, but an attack on the rule of law itself. It will necessarily have a chilling effect and thereby undermine the independence of lawyers and the protection of the fundamental constitutional rights of their clients. We have been warned.